Let's have a quick conversation about small business trademark versus copyright versus patent. I'm explaining to you in easy, everyday English the whole concept of intellectual property. Don't go anywhere. Welcome back, folks, to another edition of the Awesome Sturdy Kiwi Show. How are you today? I hope you are doing fantastic. I'm doing marvelous. If you're to ask me, if you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. In today's conversation, I want to talk to you about trademark versus copyright versus patent. Whether you are a business owner, artist, inventor, or another professional, protecting your intellectual property is a wise decision, right? IP is very important. So depending on the type of work you're trying to protect, this may involve a trademark, copyright, or patent, each of which comes with a unique purpose and registration method. So I want you to familiarize yourself with the differences that will help you determine which IP is right for you. So let's quickly have an overview here. So when to get a trademark? You want to get a trademark to keep others from using a word, phrase, symbol, or design that distinguishes your products or service from similar offerings. So you can register a trademark with the U.S. Patent and Trademark Office, the USPTO, but this step is not required. If you choose not to register your trademark, you will still have the right to use it. However, it's very important to remember this. Without a registration, you will not get the USPTO's legal protections, exclusive rights to the trademark, and a presumption of ownership. In other words, what I'm trying to say here is that you will be the owner of the trademark, but you will not be officially recognized as the owner by the government. So we actually recommend you register your trademark, things like your brand name, your logo, your slogan, to enforce your exclusive rights if necessary. When to get a copyright? Now you want to get a copyright if you want the exclusive right to sell, duplicate, or otherwise share and manipulate your work. What's slightly confusing is that as an artist, you automatically get all of these rights when you create your original work. Therefore, registration is not required. However, registering a copyright with the U.S. Copyright Office lets you protect your original work from unauthorized use. So if someone were to use it illegally, for example, the registered copyright provides actually an avenue for enforcement. More specifically, registration of a copyright enables creators to bring a lawsuit for infringement of that work in federal court. Likewise, registration is required if you want to be eligible for statutory damages and attorney's fees if that lawsuit is successful. And registering a copyright also enters into the public record and entitles the creator to a certificate of registration. And the third thing is when to get a patent. Now, you want to get a patent if you have a process, machine, chemical composition, or a design that you don't want others to replicate. So a patent is the most complex type of protection for intellectual property. It protects how your invention actually works, not just how it looks. So similar to trademarks, patents are granted and managed by the USPTO. However, unlike trademarks and copyrights, a patent must be applied for and granted to provide protections. And the patent application process is very complex and can be time consuming. Still, in our research, we found that it's worth it, really, if you want to protect your potentially valuable invention from IP theft. Now that I give you an overview, let's kind of quickly get into the nitty-gritty here. And I'm going to give you a precise definition in easy, everyday English of each intellectual property concept. Let's first dig into the trademark. Now, trademark is often used to describe both traditional trademarks and service marks. So a traditional trademark covers identifying words, phrases, symbols, and designs that distinguish goods from other products. Service marks do the same for services. So when you hear trademarks and service marks, those are interchangeable. It's just that trademarks covers products and goods, whereas service marks cover services. So registration is not necessary to rightfully use your trademark, but it does provide additional protections. New business owners with a strong brand should consider trademark registration as a vital legal step when starting their business. What are the registration requirements? So you don't need to register a trademark to use it on your products and services. Merely using the mark as part of a regular business gives you rights to the image or phrase. However, if you want to have the exclusive, the keyword here is exclusive. If you want to have the exclusive right to use the trademark connected with your products, it must be registered with the USPTO. Registration also provides public notice of ownership for the mark. It creates a presumption of ownership, which means people should think twice before using it, right? So to register your trademark, visit the USPTO website and submit an application through the Trademark Electronic Application System, the TAS, and application fees start at $225, but they may be higher. Okay, expect to pay more if you need to request an extension or choose to work with a lawyer. So once you submit your application, you need to do a few things. You need to monitor your status using TES, and it may take somewhere between 3 and 6 months to receive a response. Keep in mind, though, that it may take several years for the trademark to be registered. What is the length of protection? Trademark rights do not expire in a predetermined period of time because they are based on actual use. So your trademark will be valid for as long as you continue to use it in commerce and in connection with your goods or services. Registered trademarks only last for 10 years. To continue protections, you must renew it with the USPTO. Okay? And should you trademark your business name? That's a good question. So when you register your business with the state, your LLC or corporate name is protected at the state level. So no other business in the state can operate with your company's name. Therefore, if you plan only to do business in your filing state, you don't need to trademark your business name. However, if you anticipate growing your business to a neighboring state or nationally for that matter, trademarking your business name will give you the exclusive rights to use it. And what about registering a trademark with an online legal service? While you can register a trademark on your own, you can actually save time by using an online legal service such as LegalZoom.com or InkFile or Nolo, right? So let's talk about copyright. Again, I'm really digging a little deeper here. U.S. copyright laws protect tangible mediums of expression. So this legal term refers to music, poetry, novels, paintings, architecture, movie scripts, computer software, other original creative works. So in general, a copyright is a bundle of rights connected with each work. So everything from selling a work to duplicating it, displaying it, or modifying it. So although a creator has copyright granted automatically to each of his or her original works, registration with the U.S. Copyright Office gives him or her the ability to enforce those rights in federal court. In other words, if you want to have the protection, you got to register, right? What are the registration requirements? Registration is not required to protect a work. Still, artists should formally copyright their work if they want the ability to litigate a piece, enter it in the public record, or demonstrate ownership with a certificate of registration. To register, you want to log into copyright.gov and you want to select the type of work you want to copyright. You'll then be directed to an online registration platform where you can submit an application for between $35 to $65. So once an application is submitted, the copyright process can take from 1 month to 21 months. So you need to submit this as soon as possible. The length of time to register depends on the complexity of the application, how the application is submitted, and the payment method. What about the length of protection here? Now, the length of copyright protection depends on who created the work, when it was created, and where relevant, when it was published. So if an individual creates a piece, the copyright will last for the life of the author plus 70 years. However, where the creator's identity is unknown or where the work was created for hire, protection extends for the shorter of 95 years from the date of publication or 120 years from creation. One thing I want to say here is that copyright protection extends for the same period of time regardless of whether the copyright is registered. Okay? And there is an interesting concept that I want to talk about, and that is poor man's copyright. This is a fictional form of copyright thought to be created when an artist or creator writes and dates a description of a work or idea and mail it to himself or herself. So the point of this copyright strategy is to establish the earliest date on which the artist possessed the idea to prove ownership. Now, does this strategy work? No, it doesn't, folks. It's not covered in relevant copyright law, so it does not offer the same protections as registering your work with the U.S. Copyright Office. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another section of the Awesome Studio Kiwi Show. We are still having a convo here about trademark versus copyright versus patent. Now, let's first, so I've spoken about trademark, I've spoken about copyright. Let me talk about patent. Patents protect the unique intellectual property of inventors and designers. So common IP that can be patented includes machines, processes, manufactured items, chemical compositions, and new variety of plants. And we're showing you right now, actually a courtesy of Stephen Key via Forbes, we're showing you right now how a patent application looks like. And so unlike with copyrights and trademarks, inventors cannot get a patent without formally applying through the USPTO. Additionally, the patent application process is extremely complex and can stretch over, it can stretch out over several years. So because of that complexity, we actually recommend hiring an attorney who specializes in patent. So if you're starting a business with a product that should have a patent, we recommend starting this process as soon as possible. Very important. So the application process. The first step of the application process is to determine whether your invention can be patented. That is, whether your invention has already been publicly claimed. So to determine if the patent has been claimed involves conducting a comprehensive patent search, which can be extremely challenging. So for that reason, we suggest hiring a patent attorney. You also need to determine which type of patent you need, things like utility, design, or plant, and compile the documents necessary to complete an application. So depending on the type of patent and whether you choose to work with an attorney, patent application costs typically range from $1,500 to $15,000 or even more. So because of the application process complexity, it may take 6 months to several years before the USPTO grants the patent. What's the length of protection here? Now, this depends on the type of patent. For example, provisional patents are granted for 1 year while the applicant pursues a formal patent. Once filed, new design patents are good for 14 or 15 years after issuance. Similarly, once filed, utility and plant patents last 20 years from the application date. You can also file a patent if you want with an online legal service. You don't have to, if you don't have the money to, the funds to actually hire a lawyer, you can actually, basically work with an attorney. I mean, you can work with an online legal service. That's what I meant. So if you're starting or operating your business on a budget, consider an online legal service to submit your patent application. So if you have, so you can go on, for example, LegalZoom, you can use Nolo, or you can use InkFile, for example, to help you file a patent. All right, folks. This is actually we are in the last section of today's conversation. So I want to show you right now a comparative table on the screen right now between trademark, copyright, and patent. And you can see on the screen, you can see for each type of intellectual property, you have the cost of registration. So for trademark, you're looking at $225 to $2,000. For copyright, you're looking at $45 to $65, and for patent, you're looking at $15,000 to more than $15,000, $1,500 to more than $15,000. And what's protected? For trademark, you have distinguishing words, phrases, symbols, or designs. For copyright, you have creative works in a tangible medium, and for patent, you have inventions. The rights that are granted for a trademark, they actually prevent others from using the trademark. For copyright, they control the reproduction, distribution, and display of work. For a patent, those laws prevent others from making, using, or selling the item or idea. The length of protection for trademark is indefinite. For copyright, it kind of varies, and same thing for patent. Registration required is optional for trademark and copyrights, but for a patent, it is mandatory. In terms of whether or not you can do it yourself, the DIY difficulty for trademark is moderate to difficult. For copyright, it's very easy. For patents, it's extremely difficult. The time to file, you have 3 months to several years. Copyright 1 to 21 months, and a patent 6 months to several years. And the type of attorney recommended for a trademark, you want to hire a trademark attorney. For copyright, there is no attorney needed. You can do this yourself. And for patent, you want to hire a patent attorney. So the bottom line here, folks, is that protecting your intellectual property is an essential part of being an artist, creator, inventor, or otherwise operating a business, right? Nonetheless, the available protections can be confusing, and some of the registration processes are utterly complex. So the copyright registration process is fairly straightforward. But if you need to register, say, a trademark or apply for a patent, we actually recommend hiring an attorney specializing in intellectual property law. And if you don't have the budget for a lawyer, consider hiring an online legal service like InFile for trademarks, for example, LegalZoom for patents, or Nolo for copyrights, for example, to guide you through the process. Thank you so much for your attention. I really appreciate it. So in today's conversation, I was just talking to you about three things. So I gave you an overview: when to get a trademark, copyright, or patent. We define what a trademark is, what a copyright is, and what a patent is, the registration requirements, the length of protection, and whether or not you should DIY or outsource the process. Thank you so much. I will see you next time. But until then, remember, stay marvelous.